After the Supreme Court decision in Two Pesos, the issue quickly arose about whether or not there's a need to treat trade dress that is product packaging in a distinct way from trade dress that is product design. And this raises the related question of whether or not product design conveys the same source identification properties as does mere product packaging, and likewise, whether there's a different kind of danger to competition in protecting trade dress that is in the form of product design. On the question of whether or not product design performs a source identifying function, we have another issue, and that is our ability to distinguish the source identifying qualities of a product design independent of any labels or trademarks that may already be on the object. Because it's one thing to look at an object in its full trademarkable glory, insofar as it's a piece of product design that also has a distinctive label on it, or also has a distinctive trademark on it. And there may be a predilection to look at that and say, yeah, that's distinctive, or yeah, I know that's a, Acme product. But maybe things are different when you take away that kind of source identification. And if you treat product design as being inherently distinctive, you may not be able to actually ask the question of what is the consumer response, as you might if secondary meaning were to be required. And then, of course, as I alluded to before, we have these other kinds of concerns about effect on competition and whether or not there is room for others to compete if something is protected as product design. Now, of course, the answer to that kind of issue in the Two Pesos case was to say, oh no, don't worry about that. The functionality doctrine will save you. And so there's a lot of pressure being put on this doctrine that is not actually before the court in Two Pesos. And so we have that same issue recurring when the question shifts to product design specifically. And that takes us to Wal-Mart Stores versus Samara Bros, and the holding of the case is quite straightforward. If you have an action for infringing unregistered trade dress under Section 43A, product design is only protectable if you can establish secondary meaning. The facts are relatively straightforward. Samara makes children's clothing, these one-piece outfits decorated with appliques, these ornamentation, kind of like a cutout design that is sewn onto or otherwise put on the material. It's things like, hearts, flowers, fruits, that kind of thing. And Walmart copies it, and a jury finds trade dress infringement on the part of Walmart. And so the court sets about addressing the question of what needs to be done to establish trademark protection for product design. And at the outset, we have a very different tone of the court than we had in Two Pesos. It's a much more skeptical one. So Justice Scalia writes the opinion, and he notes that there's been an evolution in the law that has expanded trademark protection. And the courts have assumed without any kind of analysis that a symbol or device includes packaging and product design, even though the statutory hooks for these causes of action have not always been clear. So this echoes the Stevens-Thomas debate of Two Pesos. In Two Pesos, Justice Scalia wrote a very short concurrence saying he basically agreed with how Justice Thomas came down on this kind of dispute. But now I think he hints that maybe he realizes that maybe Justice Stevens had the better part of that argument about what the Lanham Act had traditionally allowed with respect to protection for trade dress. That aside, the court goes on to note that not everything that may have trademark or trade dress protection gets it automatically. And here he cites to the idea of colors in Qualitex. And so why is distinctiveness required in the first place? Well, there's an explicit reference to it in Section 2, the provision dealing with trademark registration, and these principles ought to apply to a Section 43A cause of action for infringement of an unregistered mark. But from a policy perspective, or from a perspective of what trademark law is for, a non-distinctive mark doesn't perform a trademark function. It fails to carry out the trademark functions of protecting consumers, encouraging investments in goodwill, and the like. So, of course, what we want to have is protection for matters that are distinctive. And the Act does not require every category of potential trademarks to have inherently distinctive examples. Some things can only be protected upon a showing of secondary meaning, things like color, things like descriptive marks. And when we think about whether or not a mark is inherently distinctive or not, The question turns on consumer expectations. And here the court engages in a foray into very casual empiricism. And so what does Justice Scalia say? He says that distinctive words naturally identify source. And so when you look at something like a bottle of Tide detergent or a package of Tide detergent, if you get the powder form, that any positive connotations you have with the word Tide are subsidiary to Tide's ability to perform a source identifying function. In other words, you see Tide detergent, the consumer predilection is to think, that is a source of detergent. And if you happen to have a good experience with Tide detergent, then you have this ancillary positive connotation with the term. And of course, with a suggestive mark or with a pleasant term, maybe you have some, like some pleasant associations with the word already. But all that is secondary to the source identifying function of the mark. Consumers are therefore predisposed to regard those symbols as an indication of the product, says the court. And so again, these are assumptions about what consumers make assumptions about, but this happens to be an assumption that is backed up by the statute. The statute excludes descriptive words from becoming registered marks unless there's establishment of secondary meaning. And so the court moves on. Distinctive packaging is probably like a distinctive word for purposes of consumer expectations. You see a box of Tylenol and you think like, okay, that box designates a particular kind of pain reliever, and then then you have the associations you have or not. And now the court makes the next move. The court says, but as far as we can tell, product design is more like color, a thing that needs secondary meaning, and less like packaging. We think the consumer disposition to equate the feature with the source does not exist. Consumers are aware that even the most unusual of product designs, such as a cocktail shaker shaped like a penguin, is intended not to identify the source, but to render the product itself more appealing. So a consumer sees a penguin-shaped cocktail shaker and they think, penguin-shaped cocktail shaker. And that is the primary meaning. And then if you're in the market for a cocktail shaker that looks like that, then you decide whether or not you want to buy it or not. And only as a secondary matter do you think like, that comes from the same source of the cocktail shaker at the party I had the other day. That's the assumption the court makes, that the product design doesn't really perform a natural trademark function. And of course, this is an empirical assumption. It's possibly an empirical assumption that could be disproved. Maybe we could imagine ourselves in a world in which empirical data tells us that consumers generally do associate particular designs with particular sources. And then we have, though, other policy concerns in the opinion driving us away from that potential possibility, right? We have these policy considerations about the needs of competitors and the difficulty of adjudicating these kinds of disputes. So start with the needs of competitors. The court says, if we open the door to inherently distinctive product design, we are in danger of threatening competition. Consumers should not lose out on the benefits of competition because there are, quote, plausible threats of suit against new entrants based upon alleged inherent distinctiveness. The idea that you have a market leader, someone wants to market a similar product, not in order to capitalize on the goodwill of the trademark holder, but rather to compete in a product area where, maybe you can bring in lower prices, alternatives, whatever, where there's a market. And you want to have good old-fashioned competition to decide which product is best. And so there's a concern that if we are too easy with allowing trademark protection for product design, that the market incumbents are going to be sending the cease and desist letters, sending nasty grams, sending teams of lawyers saying, you might want to try another line of business. It'd be a shame if we were to sue you into oblivion. That's a live concern for the court in a way that it was not in the Two Pesos case. And so it raises the question, if functionality was enough to make us, feel comfortable or make the court feel comfortable in Two Pesos, why isn't the functionality rule enough here? And so what the court says is that, look, we can't just think about what the substantive rules are. We also have to think about things like administration costs. And if we allow inherently distinctive product design, we are not going to put defendants in a position where they can easily secure summary judgment against a lawsuit designed for the purposes of stifling competition. Competition is deterred not merely by a successful suit, but by the plausible threat of successful suit. And given the unlikelihood of inherently source-identifying design, the game of allowing suit based upon alleged inherent distinctiveness seems to us not worth the candle. So here's the court making the very analysis that it didn't want to engage in Two Pesos. It actually makes a different assumption about base rates. It makes the assumption that says, look, in general, cocktail shaker shaped like a penguin is the product, not the designator of the source of a product. The primary meaning, the disposition of consumers is to see product first, source identifier second. And given that assumption, we're not actually going to be benefiting the purposes of trademark law too much by allowing inherently distinctive product design. At the same time, though, we're going to be giving out these, potential weapons, these, swords to brandish against competitors, against upstarts in the market, to trademark holders. And given the low base rate, given that we're not actually going to be losing out on that much trademark distinctive product design, it's no big deal if we make it harder for would-be trademark holders to seek protection. And so we have this concern, again, that's completely lacking in the court's analysis in Two Pesos. What about the possibility that there is non-functional source-identifying matter that is in fact out there? And here it's worth noting, and then here the court notes something that is worth noting, that there are other alternative protections out there. Under certain circumstances, designs can receive copyright protection, and there is design patent protection available to the extent that someone comes up with an appealing design, and one is then able to get design patent protection for a useful product in the marketplace, and that is another way to secure the interest that maybe trademark law might serve here by allowing easy protection for purportedly distinctive product design. And so note that at the end of the day, the issue here is not whether or not product design can get trade dress protection or not. It's going to be protectable either way. The choice is simply of what kind of test is going to apply in these situations. Do we imagine or do we assume that inherent distinctiveness is possible, or do we require as the court does, do we require secondary meaning? And so I think when you consider the various domains in which we may want to evaluate the choice, your mileage may vary, but I think the court gets it right here, right? Which test is easier to apply? The analysis for secondary meaning is not so different when we're dealing with product design than when we're dealing with traditional word marks. But as we discussed in an earlier lecture, the effort to analyze inherent distinctiveness is a good deal more complicated when we are outside of the word mark realm than when we are inside it, right? And so this is a test that we can apply that is, the secondary meaning test is a test that can be applied in a similar way to the way the trademark law is used to applying the secondary meaning test. Likewise, the approach taken by the court has a better correspondence to traditional common law understandings, which basically required trade dress to have secondary meaning before it could be protected, than would the alternative of allowing inherently distinctive product design. And recall, this is one of the potential criticisms of the course that the court took in the Two Pesos case. Likewise, this is arguably going to be a good deal more predictable for parties to deal with, given the uncertainty of what inherently distinctive product design is. And I think it also passes the test of better accommodating and harmonizing other trademark interests, both that of competitors in the marketplace who want to be free of litigation without merit, and also on lessening the amount of pressure that is being placed on the functionality doctrine, which of course has added pressure put on it by opinions like Two Pesos. I mentioned this before, but it's worth noting again, we have this issue of base rates. Again, how much distinctive in the trademark sense, not in the, oh yeah, that's a recognizable cocktail shaker, but in the trademark sense, identifying source, how much distinctive product design is out there? And then we have this follow-up question of how much of it is actually functional. And here, by making it harder to get in at the front end, you lessen the pressure on getting it right at the back end by having to look to the functionality doctrine. And of course, the functionality doctrine will be the subject of the next set of lectures. What then about 2 pesos? Frankly, I think that a lot of the tenor of this opinion is that 2 pesos was just wrong. But the court doesn't want to say that 2 pesos was just wrong. And even if we might think that product packaging might be inherently distinctive, the restaurant decor is not necessarily something that is product packaging. After all, why do we go to restaurants? Why do we go to places like that? It's not just for the food, it's also for the ambience. And so was 2 pesos about product design or product packaging? I think there's a good case to be made that it was actually a form of product design insofar as restaurants sell experiences. Nonetheless, they have the precedent. Courts don't like to say, whoops, we messed up. And so the court says, look, 2 pesos, it's either product packaging or some third thing that is akin to packaging. And so I think this really takes us into the realm of functionality. And maybe it's less clear in the case of the restaurant in 2 pesos, but very clear when you think of a coffee shop, right? Because you can go there not just because you're there for coffee, but because you like the layout and you want to work there. A lot of these spaces, they don't just sell food or coffee or what have you, they sell space. They sell time in a space. The court doesn't really tell us how they would treat a restaurant that is marketed or functions as a hangout. But they do give us a rule that says that if you're in a close case, notwithstanding what we just said about 2 pesos, but if you're not sure, you should err on the side of categorizing something as product design and not as being product packaging. Thanks very much.